Hi, my name is Mason Waring. I'm joined here with my colleague, CCK attorney Leah Small. And today we're going to talk about deadlines and long-term disability claims. We're going to talk about the deadlines during the initial claim process, the appeal process, and court litigation. So let's get started. First, Leah, what are some important deadlines for the initial claim?
So typically, your long-term disability policy will outline when you need to notify the insurance company that you are disabled and intend to file a claim, and potentially when you need to provide proof or evidence of your claim to the insurance company. These specific deadlines, though, can vary plan to plan, policy to policy, so it's really important for claimants to read their own policy or other plan documents to make sure they understand the deadlines that apply to them. If your long-term disability coverage was something you obtained through your employment as an employment benefit, you can often ask your HR department for a copy of the policy and other plan governing documents so you can figure out what deadlines you need to meet. And if you bought the policy from an insurance company directly, you can ask your insurance agent if you had one or the insurance company for a copy of that policy again so you can read it and see what deadlines you need to meet. Again, since it can vary so widely, it's hard to give specifics, but some examples are some policies may require a claimant to notify the insurance company of a claim within 30 days of the disability starting. Other policies may say you don't need to notify them until the end of the elimination period, which can also vary policy to policy. So there can be a lot of differences, but the bottom line is it's really important that claimants meet those deadlines, because if you fail to meet a deadline, it could result in the denial of your claim.
Right. And from the insurance company's perspective, they want and need and ask for notice of claim so they can investigate your claim in a timely fashion. Those notice of claim deadlines at the initial claim stage sometimes are strictly enforced by the insurance companies and will result in a denial, as Leah mentioned. There can be arguments around that, and it often depends on what state you're located in or what state law governs the claim, but sometimes not. So, hopefully you meet your deadlines and you don't have that kind of issue. But if you have been denied because the insurance company has taken the position that your claim is late, reach out to us, see if we can help you. So let's move next to the administrative appeal stage, and there's some real important deadlines there.
Absolutely. So oftentimes, if your initial claim is denied or benefits are terminated at some point down the road, claimants will typically have 180 days to file an appeal. Again, read your policy or plan documents, though, because some may provide for a greater amount of time to appeal. And similarly, if your policy is a private policy that's not governed by ERISA, there could actually be a shorter time frame to appeal. But again, 180 days is typical, and this is a really critical deadline, especially under ERISA governed claims. If you fail to appeal by that deadline, then you may not be able to pursue your claim any further, because typically going through with that administrative appeal is a requirement before you can pursue your claims in court.
Yeah. Try not to miss your deadline.
Yeah.
Really important. And there can be, again, like missing notice of claim. If you're late, there could potentially be an argument, but there's usually less arguments to be made. So the administrative appeal deadlines are often strictly enforced and will be enforced by the court as well. So really, really pay attention to those deadlines. Let's move next to court litigation, and what deadlines should the claimants be paying attention to there?
So as we've said many times during this video, read your policy and plan documents carefully. Many LTD policies have what we call a contractual limitation period, which is a provision that outlines the deadline to file suit to obtain benefits under that policy. Some policies don't have that kind of internal litigation deadline, and so in those cases, oftentimes the deadline to file suit will be governed by state law or the statute of limitations that the state provides. Again, though, really critical to understand what that deadline is and to ensure you meet it, because if you fail to file suit by that deadline, again, you could be losing your rights to your benefits entirely.
Many times the insurance company will put the actual deadline to file a lawsuit in the denial letter. So if you get an appeal denial letter, it'll say, hey, you have until such and such a day to file a lawsuit. Sometimes not. If you're in a situation where the insurance company typically you'll get notice of a late decision once you're in court, because the insurance company would maybe file a motion to dismiss in court to do that. But again, really important to pay attention to those deadlines. There can be arguments to make in response to arguably missing a deadline, but you really want to get ahead of that. understand what your rights and obligations are under the policy, and meet your deadlines. If you have questions about deadlines in your case, if you've been wrongly denied or need to file a claim, please reach out to us. Our number is 401-331-6300. It costs nothing to speak to us to see if we can help. You can also find us online at www.cck-law.com. Please subscribe to our channel and like this video. If there's a topic you'd like us to cover in the future, leave us a comment. Thanks very much.
Thank you.